Hello, everyone. How's it going? This is immigration attorney Moumita, and I'm coming to you live to talk to you about immigration and to see the questions that you may have on your mind today on this lovely evening. Thank you for joining me. For those of you who don't know who I am, my name is Moumita Rahman, and I am an immigration attorney. I am based in New York, but I work with clients all over the U.S., so make sure you write my number down. It's 212-248-7907. And I want to talk to you about something really important today. It's a question that I get from a lot of people who want to know, how long do I have to live together with my U.S. citizen spouse before I can file? How long are you required to live together to show to immigration before you can actually file for a green card? Whether this is for a joint marriage case that your spouse is helping you file, or even if it's for when you file for VAWA. Now, these are two separate things, so I'll talk about these two things separately. So let's talk about the first one. The most common question that I get when it comes to marriage cases is, can I file now, or do I have to live together for years before I can file with my spouse for my green card? And the answer is that when it comes to a joint marriage case, there is no specific amount of time that you have to show that you've lived together in order to get your green card. And in fact, when it comes to a regular marriage adjustment of status case, and for this, I want to be very specific. This is the case where both the spouse, the U.S. citizen spouse, and the non-citizen spouse are filing together, and there are no problems in the relationship. You don't actually have an actual requirement to show that you're living together. So in fact, in a regular marriage case, you don't even have to live together in order to get your green card. However, in these cases, if you're not actually living together with your spouse, then it can definitely make your case a little bit more difficult, because anytime that you and your spouse don't live together when you're filing jointly, then immigration will give you extra scrutiny. So you definitely need to be prepared to show why you're not living together in the same place. And usually you have to have a good reason for it. It can't just be because I don't want to live with my spouse. It should be for a reason such as, we live in different I go to school here, or they're in the military, or my job required me to move for this, X, Y, and Z. So you need to have a good reason for that. But also you need to be prepared for the fact that immigration is going to give your case more scrutiny. But the bottom line is that if you're doing the regular marriage immigration case with your U.S. citizen spouse, there's actually no amount of time that you need to show that you live together at all. But it is completely different if you're doing a VAWA case. If you're doing a VAWA case where you need to file by yourself because your spouse is not helping you, or something has happened that makes it difficult for you to file with your spouse and they won't help you, then you do actually have a requirement of showing that you have shared a residence with your spouse for any amount of time during the relationship. And I do want to talk to you a little bit about this, because I've had people who've come to me who have certainly been, gone through very bad situations with their wife or with their husband, but they never really lived in the same house. For VAWA, that is a disqualifier. But there are certain times where you might live together for a short period of time, and then you have to leave, or the living together part happened before marriage. Now, I want to make something very clear to you. If you need to file for VAWA because you're suffering at the hands or the mouth of your U.S. citizen or green card holding spouse, and what I'm talking about is either you're suffering physical abuse or emotional abuse, you can have just 1 day of shared residence and still win your case. And we have actually won a case where our clients only had 1 day of shared residence. So it is a legal requirement when you're filing for VAWA. You do have to show that you shared a home with your spouse. It cannot be a temporary visit. It cannot be just for you sleep over on the nights. You actually have to have lived with your spouse, and you have had an intention to have the shared residence together. Okay, so two different types of marriage cases: one where you're filing together, and the other where it's a self-petition through VAWA. They have two separate requirements for showing about shared residence. Now, another question I get is, how long do I have to be married before I can file? how long do I have to be married before I can file? And again, I'll talk about it in the two different contexts. The first context is when you're doing the joint case, and the second context is if you're filing for VAWA. Now, you can file, the bottom line is this actually, for either of these two cases, you can simply file as soon as you have your marriage certificate. I don't care if you give it to me, you got married at 8 a.m. at City Hall and you're filing today, that counts for immigration, okay? But you do want to keep one thing in mind. If your relationship itself has not been very long, then you will have to work a little bit harder to show that your marriage is legitimate, that it's made in good faith, and that it's real. So very, very important things. So keep this in mind. And if you're looking for an appointment, you want to find out what your options are, you can definitely give us a call, 212-248-7907. We do schedule people for case evaluations with my legal team. You won't be speaking with me directly, but my legal team is handpicked and selected and trained by me to evaluate your case and move it forward with our office, okay? So, all right, let's see. Thank you so much. Martha Zulu saying, hello, my favorite lawyer. Hi, Martha. Nice to see you. Bombay Brian, nice to see you. Godchild, nice to see you. All right, so I'm going to go ahead and answer some questions right now. And I am live streaming on 4 different platforms. I'm on TikTok, YouTube, Facebook, and Instagram. So thank you again. Thank you so much to everyone who's watching me and following me and asking questions. I really, really appreciate it. So, all right, let's start with Instagram first. Let's see. So I do want to address this. I generally really hate to respond to negative comments because it does bring me down a little bit, but I have a comment from Vikas Tony who's saying, Madam, calling to your office is no use, waste of time, no appointments, not recommended to anyone. I'm really sorry you feel that way. Now, here's the thing. If you're calling me, I understand that there are different types of immigration cases. We simply do not give appointments to every single person because we could not accommodate every single immigration case. One of the reasons why we are so successful at what we do through VAWA and marriage cases is because of the fact that we don't do every type of immigration case. So because Tony, I'm sorry you felt like it was a waste of time, but I definitely wish you a lot of luck in your immigration journey. Let's see. Sunny Kumar, hello. PZ, hi. If fiance is in Mexico and pregnant, what can we do? From Sonia L. Sonia L, so thank you so much for your question. If you are a fiance of a U.S. citizen and you're pregnant and you're stuck outside the U.S., what are your options? One of the easiest things is to actually just go ahead and get married so that your then future spouse can start the process for you for an immigrant visa. However, if you are in Mexico, fiance visas are, I believe that in Mexico, you are going to be able to get an appointment for a fiance visa. So if you're in Mexico and you're pregnant and the person, the father of your child is a U.S. citizen, they can petition for a fiance visa for you. But in my opinion, I generally find it's better to do the spousal immigrant visa first, okay? And if you have a question, go ahead and drop it in the line. How long does the citizenship certificate interview take? From El Miki. So if you're filing for the certificate of citizenship, that means that you already acquired citizenship through either through one of your parents or through birth, and it was just never really registered. These cases don't always have an interview, but the process itself is usually more than a year long. How long after you get your social security number can you expect your green card? From Sarika Mangro. Very good question. So once you get your when we're going through the immigration process, it is natural to try to measure out the time that things are going to take by certain landmarks, right? When you get your fingerprints, and then when you get your work permit, and then your social security card, and then ultimately you want to get your green card. But I do have to let you know that when you get your social security card, or when you get your work permit or get your fingerprints, none of that is actually an indication about how long you're going to have to wait. Everything will 100% always depends on your category that you're filing under and the jurisdiction in which you live. Some categories will be waiting a long time, like for my asylum clients who were approved for asylum and who are now filing for a green card, you guys are going to be waiting about 2.5 years for your green card process to go through. Roughly. And for those of you who are in the marriage process, that will probably take anywhere from 6 months to a year and a half, also depending on where you live. So it really, really depends. What is the shortest VAWA approval you have gotten from Simply Oni Girl? So the shortest VAWA approval that I've gotten is actually a little over 1 year. And we actually have a video talking about, we just got approved this month, 7 VAWA cases so far. That is 100% amazing. I love it. 7 VAWA cases were approved by us, by immigration that were filed by my office this month. And pretty much all of those cases were roughly over 1 year. But before anyone gets excited or gets worried about how long their case is taking, let me explain something. There are actually a couple of different types of VAWA cases. And for these cases, these are what I call my abeyance cases, because for these 7 clients who just got approved for a VAWA, they already had their application pending with immigration because they did the joint process with their spouse, and their spouse was not going to help them at all. So I had to come in and step in and interfile a request to file for VAWA. And it appears that the Vermont Service Center is processing these on a different timeline than my other VAWA cases. Everybody else is still taking about 2.5 years or more. All right, Nettie on TikTok is asking, 10 months since my I-130 has been under review. Should we hear something soon in California? Nettie, 10 months I would say is pretty average. I do feel that the I-130s are ranging anywhere from, I would say 8 months to a little over a year. And even in some cases in my office, we're seeing I-130s take even longer than a year. Don't ask me why, but 10 months is pretty much right on the dot. You can always check to see what the current processing time is if you go to the USCIS webpage and click on their processing times page, and you can make an estimate about how long is just too long. I received an RFE for medical exam and I sent it. Now, how long will it take to get a decision? So congratulations. I want to let you know this one thing. If you're filing for a green card, right? If you're filing for a green card and you've been waiting and waiting and waiting, and all of a sudden you get a request for evidence asking you for the medical exam, right? This is very different from that courtesy letter that you might get. A lot of people freak out when they get this letter. It's called a courtesy letter to say that you have a deficiency in your case because you're missing the I-693. However, that is very different from the request for evidence that you may get where immigration will request for you to complete the medical exam and mail it to them. When that happens, that is a wonderful sign. It's a beautiful sign. It's a great sign. It means that they're pretty much ready to issue your green card and they just need that medical exam. So once you get your medical exam in, I would say give it about 60 days or so to see your approval. But obviously it might take longer, but I would say 60 days is probably average. After I get my citizenship, can I apply for my husband from Pakistan because he's in Pakistan from Visa Khan? Visa Khan, yes, you can. And if you're a green card holder, you can apply for your spouse overseas right now. You don't have to wait to become a U.S. citizen. So I would actually recommend that you start your process right now because your spouse is going to be waiting a long time. How long is your review process of the case before it's sent to USCIS? I'm waiting a little bit longer than I thought, from John 993. So John, I do understand it's being a long time. Now, here's the thing. In my office, I am literally the only one who can review these cases. I care about my clients so much. We do a really, really careful check. Otherwise, if it weren't for me, if everybody, including my staff, if they didn't have to wait for me to review everything and make sure everything has the final, the everything is, the T's are all dotted, the T's are all crossed, the I's are all dotted, right? I do a lot of checks and then we have a large review process. So it does take longer. It takes longer than I would like. And I understand that it creates stress for our clients, but please understand that if it's taking longer, then it's because we want you to have a good outcome. So definitely it can take, I would say it's taking longer. I don't want to say exactly how long because I just did the math, but you give us a message, give our office a call and just say that you wrote me a comment on YouTube to look into your case. Okay, thank you so much. Hi, Kira, nice to see you. And thank you, Gabby. I really appreciate that. I feel like when the firm takes a little longer, it's a good sign they're taking fragile care. I do want to say one thing. It's not like, if you're waiting a long time at our office, it's not because we've forgotten about your case or it's sitting in a box hidden away. It's because it's waiting for my review, which is a really critical part of your process. Ok, Marco Quintero me dice, aquí estoy en vivo y a todo color esperando alguna respuesta positiva. Gracias, Marco. Muchas gracias. I think I understand all of that, guys. My Spanish is still a little bit beginner, I feel. For VAWA cases, can you get a work permit and travel permit while you wait? From Vina Mussinger. So yes, you can. When you're filing for VAWA, it is the same as an I-485. It depends on certain issues that you may have with your cases. If you already have a removal order or if you're currently in removal proceedings, then it is not going to be possible to get a travel permit, but we can still get you a work permit. And if you don't have any issues, like you don't have a removal order that is unexecuted or executed, and you're not in the immigration court system, then for all those clients, we are getting both the travel documents and the work permit. So definitely that is a huge advantage of filing for VAWA. That really helps out a lot of people. What if my spouse didn't add my name to the resident lease agreement? Can I still go for VAWA? That's a good question. What if your spouse refuses to add your name to your documents? What if your spouse refuses to put your name on the taxes or on the lease or on the bills or refuses to add to the bank account? Can you still file for VAWA? The answer is yes. Yes, you can. When somebody you are married to refuses to put your name on these documents, that is actually considered to be economic abuse, financial abuse, and it's just another method for them to control you. And it's something that happens a lot in our VAWA cases, and that's one of the reasons why we need to file for VAWA. We've definitely had plenty of cases where there were no accounts together, there were no returns filed together. None of that means that your marriage is fake. None of that means that you're going to fail, okay? So definitely, Kobe, give us a call at 212-248-7907. Is it true that the only cases you're accepting at your firm right now is VAWA case? From Eleanor Truly Blessed. Eleanor Truly Blessed, it is mostly correct. We're only taking 3 types of cases right now, which is VAWA, marriage cases, and asylum cases, but not all asylum cases and not every single case. I still do sometimes get very careful with the type of cases that we take, but the majority of our cases that we accept are VAWA cases. My DACA expires next year in August. Do you recommend renewing now since DACA is in peril? From the OG Cada. OG Cada, if your DACA is expiring next August, that's pretty early to be filing for renewal. Look, DACA is so uncertain, right? So what happens if, you currently have DACA and it's at danger of completely going away? Should you file for your renewal right now, even if your card is still valid until well into next year? And the answer is, it probably won't make a difference. Like if your card is expiring if your DACA card were expiring in the next 6 months, then I'd say go ahead and get your initial your renewal application filed. But since it's almost 10 months away, let a few more months pass and then do your renewal, because if you apply more than 6 months ahead of your expiration date, then there's a danger that may also get rejected. Not like the worst thing, because you can still file, but still, why go through that? My husband is in jail for aggravated assault and I want to file for VAWA. Will I tell immigration because he's in jail? I have evidence of emotional abuse. From Amastonia. Amastonia, you should definitely give us a call. We would love to help you with your case, okay? 212-248-7907. If your spouse is in jail for an aggravated felony, especially for assault, that's one of the situations where probably you are most likely experiencing a lot of things in the home. So it's proof. I would use it as proof. They're not going to contact him anyway. Even then, all you need is emotional abuse to win your VAWA case. So Amos, give us a call. Price for the consultation, our evaluations cost $150. Oh, hello. Hi, how are you? Can my spouse travel abroad while applying for removal of conditions from WOSA? Hi, how are you? So this is a great question. If you have applied for removal of conditions, can you still travel abroad? And the answer is yes, because the entire time that your removal of conditions application is pending, you are still considered to be a resident of the United States. So you have all the privileges, including being able to work in the United States and being able to travel internationally, even after your card is expired, as long as you have your I-751 removal of conditions application pending. You will get a receipt upon filing that serves as an extension of your case, basically of your card. And right now, USCIS is giving extensions of 24 months. Okay, so you will be totally fine, and there's no issues at all. And it's good to see you. Last month I filed for VAWA, but no answer and no receipts receiving. So good question, because people get really worried when you file something with immigration and it's been like a month or 2 months and you still haven't gotten receipts. So should you be worried about that or not? Now, I would say that these days we see a wide variety of ranges for how long it takes to get back a receipt. And the receipts can take, I would say, sometimes it's under 30 days, and sometimes you're waiting more than 2 months for certain receipts. I wouldn't be too worried. As long as we have proof that it's been filed, immigration, USCIS will get around to issuing it. You have to give them a little bit of time because sometimes they get backlogged as well. Can lawful entry alone, i.e. Kilantan alone, qualify you for a green card, or do you also need a US or LPR sponsor from Art Show? Good question. So if you have a matter of Kilantan entry, which is basically a wave through entry, do you still need a US sponsor? And the answer is yes, you do, because all that is proof of your entry. You still need to have an eligibility category, a sponsorship type, either through family or employment or through a humanitarian case. If it's required even to get a green card. Ibre, we'll make sure we give you a call. Give us a call right now, Ibre, and let us know. Let's see. Any tips on how we can bring relatives from war-torn countries like Ethiopia, Tigray? So very good question. It's a really hard situation. Immigration, the US immigration system is literally so, it's really out of touch with reality. And the only, you need to, first of all, if you want to bring your relatives from overseas, they're in a war-torn country, you first have to make sure that you have the basis to apply, such as, are you a US citizen who's trying to sponsor their parents or their spouse or children? And sometimes you can ask for an expedite of the case, but if they're in a preference category relatives, such as a brother or sister, then they're stuck waiting. They can always apply for a visit visa if it's possible, and try to, sometimes if they even end up at the border, they might be able to do humanitarian parole, but it's very, very difficult. I'm getting married next month and I have a deportation letter. Can I send my marriage-based case anyway, from Anna Luab? So Anna Luab, the answer is no. If you have a order of deportation against you, but you're married to a US citizen, it is not that simple, but it can be done. First of all, we definitely need to see why you got deported, what happened, because getting married to a US citizen alone may not qualify you to get a green card. We first need to see why you got deported, when it happened, and we would need to take a lot of additional steps to rectify that first before you would be eligible for a green card, okay? But do give us a call, 212-248-7907. All right, everyone, that's all the time that I have for today. Let's see. Let me answer one more question. How long will it take for refiling a denied VAWA case? I got a denial due to an insufficient RFE. The government asked for joint accounts and I didn't have, because my spouse thought I was stealing her money. What should I do? From Samuel. Samuel, you need to give us a call, because if your case got denied, because they're saying you don't have sufficient evidence of your marriage, 9 times out of 9, it's usually because it wasn't well explained. You know, in a VAWA case, the government is required to use any credible evidence. Your affidavit counts as evidence as well. Obviously, you need to try to do something like pictures, any other affidavits from witnesses to show that you were in a real marriage. But it does not mean that you can't file for VAWA a second time, okay? As long as you're still legally married or your divorce is not more than 2 years old, I would say give us a call. Let's look to see if we can help you, okay? All right, everyone. I hope you have a wonderful, wonderful night. And see you all again next time. Make sure you subscribe, make sure you follow me, and make sure you share my videos with somebody you care about who could benefit from this information. Okay, that's my one favor to ask of you tonight. All right, have a wonderful night.